Welcome everyone to this DCI webinar on GenAI with a specific focus on competition law and policy. My name is Bo Hayden, and our mission at the Dynamic Competition Initiative is to develop and advance innovation-based dynamic competition theories, tools, and policy processes adjusted for the nature and pace of innovation in the 21st century. We call this competition policy for a dynamic world. DCI is co-hosted by UC Berkeley and the European University Institute. We run a number of programs with different stakeholder groups, including policymakers, law and economic professionals, industry representatives, and academics. In particular, we run the Dynamic Competition Policy Lab, the Young Scholars Program, and industry roundtables, in addition to webinars like we're going to have today. So without further ado, I would like to welcome today's moderator, Thibault Chapelle, who's Associate Professor of Law at VU Amsterdam and a co-founder of DCI. Thibault, the floor is yours.
Yes, thanks a lot for having me and for organizing this great webinar, more timely than ever. So before I go to our panelists, I will introduce them all. Now, I'll keep it short because we only have 2 hours, and going through their biography could actually take us about an hour and a half. So in the order that I have here, our first speaker will be João Vareda, who is Deputy Head of a unit at the DG Comp at the European Commission. Then we are joined as well by João Pereira, who is a senior economist at the Portuguese Competition Agency. Now, what I forgot to mention is that for our very first speaker, as you may be aware, and as you will hear today, the European Commission is currently conducting some market studies on the subject. As for the Portuguese Competition Agency, the agency published about, what is it now, 8 months ago, which feels like 10 years ago in the space, but a report on GenAI. So thank you very much for joining us. Then we are joined as well by Blanche Savary de Beauregard. Now, I do pronounce it the French way because I'm used to people butchering my name in the United States. So I'll be curious to hear how they do pronounce your last name when you go to the US. But thanks a lot for joining us. You are General Counsel and Secretary of the Board at Mistral, a company that is one of the main players in the space. Now, I won't say that you are the player, because otherwise we will hear dominance and Article 1 and 2 of the TFEU. So I don't want to put a spell on you, but very, very happy that you are joining us today. We are also joined by Yann Guthmann, who is the head of the Digital Economic Unit at the French Competition Agency. The French Competition Agency is also doing some work and some market studies on the subjects, and I believe that Yann may have a thing or two to tell us about what's going on within the French Competition Agency. Yann, it's always a pleasure to be on the panel with you. So
nice to be here with you all also.
And last but not least, Thomas Vinje, who is a practitioner, but not only a practitioner who is very well known to all of you in the field of competition law and technology, but also a professor of competition law at Bergen University. Thomas, it's also a real pleasure to have you here. Your experience, I'm sure, will enlighten us and put some perspective on the subject that is, to the least you can say, triggering a lot of hasty comments. And so because the plan of this webinar is not to be outdated, in just a couple hours, we count on you for some perspective on what's going on in the space. Now, what we're going to do is the following. We have divided the conversation in 3 different chapters. In chapter 1, you will hear about all of the speakers about the reasons why we are organizing this webinar and the reasons why competition agencies and practitioners and companies are considering competition law to be relevant in the space today. Then we move on to part 2 of the discussion, in which we'll be discussing issues and maybe not just the issues, but also the opportunities that we see in upstream markets. So here, what we have in mind is what's happening inside the machine, in a sense. So inside the creation of AI models, inside generative AI applications. And then this will be part 3. We'll be moving on to the downstream market, or in a sense, we'll take a step back and look at the real world, right? So how generative AI and AI foundation models and key companies in the infrastructure layer are or will impact the real space in which we live. So that's the plan. If you have questions, you can use the Q&A function. It's nice to see participants with us. And of course, the video will go on YouTube. So make sure not to say anything too catchy, because this will be eventually used for training purposes. All right, on that good note, I'll move on now to our very first speaker, Blanche, who will, from the get-go, give us a view of what's happening from the ground, right? So that we have a grounded conversation and not just an academic conversation, although I love those, but that is totally disconnected from reality. So Blanche, thank you for joining us, and the floor is yours.
Thank you, Thibaut. I don't know if it's too catchy for a beginning or not, but I actually like your spell on dominance, and really hope that there is a future for European companies to be to have a chance to be dominant. And this is what we're trying to do. At least we're trying to compete very hard and make ourselves a place in language models, which we are doing great so far. So as a starter, this is what we target to do. We are in a kind of unique position because we are EU independent and pure player. So by independent, I mean we are not under dominance of another player that would have some established place on the market. We are not under influence. The company is today managed and owned by its 3 French founders. And they have founded this company after having been employees of US big corporations, indeed to be independent and pure players. So less than a year after that beginning, we have already launched a lot of models. We are having a platform, we are having a chat, we are having a lot of partnerships with a lot of big companies. And I think it's fair to say that we are competing with the most performant models on the place. So this comes with a lot of challenges, because our competitors, some of them have very deep pockets, deeper than ours, and they are integrated for some of them on the whole value chain. So this makes the challenge super interesting. And we aim, there is a sense of urge also that makes it a lot more interesting, even because we need to hit the market fast. We need to make ourselves a place with customers super fast. And we are coming after some players that have already a lot of contracts and a lot of adoption on the markets. So the targets for us is to be ubiquitous, so to be adopted by a lot of people, to be portable, so cloud independent and cloud agnostic. We are willing to be accessed by customers wherever they are, on clouds, on marketplaces, and even on premise. And we're also super willing to give a lot of our models away, so to say, because they are open sourced. So we open sourced a model later than yesterday, and this is one of our targets, to trigger a lot of adoption and a lot of portability. And we are to be able to do that, we are in vital need to contract with the whole value chain, and this will be the topic of this discussion, because on the upstream markets, on the downstream markets, we are dependent on a lot of actors, and we have a lot of work to access those dependencies. So we have already announced, as I said, a lot of contracts and partnerships. And today at Mistral, we are super optimistic that the markets is rather open for us. And we are also optimistic that the major actors have have a sense of the fact that it is super important to keep this market healthy, competitive, and open, and they are willing to contract with us. And we are also super sensitive on the fact that the authorities, the competition authorities, are willing to keep that state of facts real for the future. And in this super fast evolving market, there will be a lot of work for sure in the next few months. Thank you very much.
Yeah, if I may just already do a quick follow-up, do I hear you well that one of the main challenges is not technical in the sense that it's not as if you didn't know how to build a model as good as other models, but it's commercial in a sense. So, you know, it comes to market adoption.
Yeah, I think it's fair to say that. I think it's fair to say that we have very good recipes, and we've managed to build some of the best models with less means than other companies. So you can deduct what you want from that, but we tend to deduct that we know how to build the best models.
Yeah, all right. I'm asking the question to prepare already chapter 2 of the conversation, but thanks a lot. I'll now move on to some of our policymakers here in the room. And I'll start with, so I'm going to have every time to give your first and last name, João Pereira from the Portuguese Competition Agency. As I said, you published already a report, very informative. When it comes to teaching, it's a dream because you have so many great graphics that I can use in the classroom. So thank you for that. But the floor is yours and I'm curious to see how indeed we will see correlation between what you're doing, your concerns, and what Blanche just exposed.
Yes, thank you so much, Thibaut. Thank you so much, everyone, for the opportunity to discuss this fascinating topic and try to share some of the initiatives that we are carrying out here in Portugal concerning GenAI. Just before starting, just give you certainly heard this before, just giving this first remark that all the opinions that I will express are strictly personal and they do not necessarily represent the views of the ADC, the Portuguese Competition Authority. But going back to GenAI, I mean, the topic of today's discussion, just giving a little bit of context before going into the nitty-gritty of our issues paper. So basically, we have been witnessing over the past decades some advances in machine learning, deep learning, and now we have GenAI, which basically goes a step further by being able to generate new content. I mean, in the form of text, the so-called LLMs, the large language models, but we have also new content in the form of images, video, sound, among others. And we have also witnessed the emergence, and we have already listened to Mistral, but we have witnessed the emergence of the GenAI chatbots for the general public. We have all seen the ChatGPT emerging, Google Bard, which is now named Gemini, Mistral, and among others. And there's also, although this is probably going to be the main focus, there's also a broad range of application of GenAI that we should not forget, both at the enterprise level, where basically GenAI foundation models can actually be fine-tuned to streamline a specific business operation. And we can all expect this to become a powerful assistant for many business operations. And also at the personal level, where basically GenAI can actually process data and give tailored advice on a number of issues. And here I'm thinking about, for instance, health, work, financial decisions, leisure activities. There's a number of, let's say, real practical applications for at the personal level for the final consumer. Now, it was a little bit in this context that the Portuguese Competition Authority decided to look at the competition dynamics of the GenAI market. And in November last year, basically, we published the issues paper. It's basically a market study named Competition and Generative AI, which you can basically check on. It's published on the website of the ADC, and there's an English version. So feel free to read it if you're interested in these topics. I will just go very quickly through some of the main findings of the issues paper. We have looked at a little bit more like the technicalities, let's call it this way, the different stages involved in the creation of a GenAI model. I mean, there's the preliminary stages of designing the model architecture, data collection, data cleaning. There's the training of large data sets to actually build the knowledge of the model. And then there's the fine tuning to prevent, let's say, things like hallucinations or biased and harmful outputs. And then there's the deployment, which we already discussed a little bit, which you can have an open source model or a more kind of closed source model. I mean, there's different advantages and disadvantages associated with this type of models. And I think here we are really going into the interesting part. The issues paper also alerts for possible risks for competition in the various stages of the value chain. And we already talked about the upstream. So the upstream, we basically want to ensure access to key inputs, which are necessary to actually build a GenAI model. In here, I'm talking about cloud services, data, AI hardware, skilled labor, financial resources. We are going to go deeper into these issues along the discussion today. But here, the focus for a competition authority is really on vertical foreclosure practices, such as refusal to supply, self-preferencing, or degradation of access conditions. And then we looked at the GenAI market itself. And here we are talking about ways to mitigate the risk of market tipping in the GenAI market. And here a competition authority and let's say a lawmaker should really be concerned about locking strategies for users, or tying strategies that try to basically leverage market power from one market to capture basically the GenAI market. So here I'm thinking about ecosystems of products that integrate GenAI chatbots, for instance, in search engines, operating systems, and this can actually create this leveraging of market power. And then, of course, the downstream markets, it's also important to look at and to ensure access to the GenAI models by downstream developers. And here there are already many firms, including XP, the OpenTable, among others, that have created plugins, for instance, to interact with ChatGPT. And so it's important to look at this downstream part of the market as well, to ensure, again, and to prevent that there are no vertical foreclosure practices from, let's say, a leading player in the GenAI market. And then we looked a little bit, and then I will end on the competitive forces in the GenAI market. And here we are witnessing a little bit of an oligopoly market structure right now. We have the current leader, which is ChatGPT, which basically has a sort of a first mover advantage. We have a little bit an aspiring challenger, which is Google Gemini. There's rumors right now of talks between Apple and Google to ensure an exclusive placement of Gemini in the iPhone. So let's look, that's something to be aware of and to be vigilant about. And then there's, of course, many followers, Meta, Amazon, Mistral, among others. Something that we discovered while drafting the issues paper is that quality is going to be a key dimension of competition in this market. And there are already many metrics out there to assess the quality of a GenAI model. And so this is something that one should bear in mind. And then finally, a question that we kind of try to reflect upon and try to actually come up with an answer is whether the GenAI market is actually prone to a winner-takes-all outcome, like we have seen in many digital markets. And indeed, there are some characteristics that may lead to high levels of concentration. I mean, these GenAI models are heavily dependent on data, computing power, skilled labor, and so this can lead to market concentration. There are also some network effects at place. For instance, there's this question whether the input data, so the data that is put by the user in the form, for instance, of prompts or uploaded documents, or even user feedback, could actually be creating a positive feedback loop that would lead to market tipping. Here, there's still some discussion about this. There's right now, we've seen a lot of these GenAI chatbots running a sort of a freemium version, which might indicate that network effects may be limited. Otherwise, there would be, let's say, a free access, like in many other digital services. So let's remain vigilant about this as well. And finally, one factor that may lead to market tipping is actually the creation of an ecosystem. And here I'm again talking about the downstream, let's say, markets, where basically there's a number of developers that are using plugins to develop, let's say, services for final users. And so again, we see, for instance, ChatGPT creating the GPT store, which has the same sort of dynamics that you see in an app store. And so you can maybe have a sort of indirect network effects situation where developers are attracted by chatbots with more users, and users are attracted by chatbots with more developers. And this, of course, could lead to market tipping. But again, there's still some uncertainty regarding this. There's constant innovation in these markets. It's actually difficult to keep up with all the evolution and innovation in these markets. There's consumer heterogeneity, there's product differentiation, and this all works against market tipping. So in sum, I mean, it's important that competition authorities and lawmakers remain vigilant. There's quite a degree of experience over the past decade in dealing with the challenges of digital markets. And so, I mean, public institutions should be able to intervene more effectively in GenAI. And that's all for now. Thank you so much.
Yeah, thanks a lot. So, I mean, already with your two presentations, we covered what I think would define the dynamics in the space. So one is quality, right? So if the model is obviously bad, no one will use it. But then it's not the end of the story. Then you have the ability to indeed have market adoption, benefit from increasing returns. You've mentioned winner take all. The CMA, another agency that is quite active in the space, just released today its updated report. And they do mention toward the end of the report that winner takes all is a possibility in those markets, especially if indeed you have a learning effects. And I was looking at the license of Grok, that's XAI, and they do mention in the license that they use, the prompt of the users to actually improve the model. So that's a possibility. But on that good note, we move on to another enforcer. And here I have in mind Yann. So Yann, I count on you to tell us where you disagree with the Portuguese competition agency approach, or joke aside, to tell us what is the French perspective on this ecosystem and market.
No, I agree with what João said. He did a very good presentation of the issue and challenges of GenAI. So I try to avoid any repetition with what it said. Usual disclaimer, I'm also speaking on my own behalf, and the view expressed do not necessarily represent the view of the authority. And maybe to add to what João said, GenAI is a very complex sector, and it's evolving very quickly. And so I try to think that a competition authority were kind of a collective intelligence to tackle this big sector. And so us at the French Competition Authority, we thought that we are part of a global process regarding how to understand GenAI and what are the competition problems that arise. And so that's why for our sector inquiry, we focus on some part of a GenAI. We cannot do the whole value chain. And so we focus specifically on the upstream markets, so cloud compute, data, skills. And we also look at the problem of the issue, I don't know yet if it's a problem or not, but the issue of minority stakes by major tech players in the GenAI actor. So we launch a public consultation. We have around 50 answers, so it's a good result for us. And our opinion is should be expected in June, so only 5 months. So it's very short for our standards. To have a comparison, for example, our cloud sector inquiry, it took us 18 months, but we don't have the luxury with GenAI to have so many months to do a comprehensive study, because like João said, it's evolving very quick. Since February is the date at which we launch our study, we have many models that have been released. The last one of the Cloud 3 series. We also heard of the partnership between Mistral and Microsoft, and many other things that I don't recall. But there's so many things that us, competition authority, we need to act quickly. And so we cannot encompass the whole thing, but if we divide our works between competition authority, I think we can cover the whole picture. And we mentioned the Portuguese authority, but also the CMA did a study on GenAI that focus on foundation model. And Christophe Carugati just put in the chat that they released the update a few minutes ago. And I've also heard that I think it was the last 2 weeks, the Canadian Bureau launched also a public consultation on GenAI. So it seems that a lot of authorities are investigating the GenAI because it's of utmost importance for the whole economy. And it's something that we heard a lot. We don't want to repeat the same mistakes with the beginning of the digital web. That was I wanted to say as a starter.
Yeah, so actually I've went around different websites and I found that about 10 public institutions, not all competition agencies, but also Ministry of Economics and so on and so forth, are investigating generative AI. So it seems that there is a world movement. And I'm here also to mention that the AI Act is highly relevant in shaping the market dynamics. So I'm so sorry to say for all of you who thought the DMA was already plenty enough, but the AI Act would be something for you to consider. Maybe, Yann, just a quick follow-up. Would you publish all the contribution you received? And
no, we don't do that at
so
the
can you give us just a sense of, whether the industry also responded to the consultation without naming names necessarily, but
no, we have answers from all the different kind of stakeholders, so it's very representative. For example, maybe one answer I can say that France Digital, that is a federation of different startups, answer or public consultation, and they also publish a study regarding GenAI, for example. And regarding the reports you mentioned, I forgot to mention that at the French level, there was a report whose name is Giving Meaning to Artificial Intelligence for National and European Strategy, that was released in March, for example. So it's part of a global process. And there's a lot of issue, and competition is just one part of the issue of GenAI. And for example, in this report, they suggest that they should release kind of the rules regarding health data, for example.
Yeah. So when the French start giving English names to their report, there is a willingness to have a world impact. And as you mentioned, indeed, competition is just one of the many issues, but they're all interconnected.
Yes.
If for the copyright you say that no training is a law on freely accessible data, it will have impact on market dynamics, which brings me to chapter 2 of our conversation, in which we discuss the upstream market and the challenges, because as lawyers and policymakers, we tend to focus on challenges as opposed to focusing on the opportunities. But some of you already mentioned that, overall, it creates a lot of dynamism, and we may welcome generative AI and foundation models. So we thought we'll divide the discussion into separate categories, although it's a bit academic, but we'll start first with compute. So here we have in mind GPU, TPU, but also cloud. So very much the infrastructure layer. And I'll go back to you, João Pereira, for your take on the market dynamics. Again, just looking at the infrastructure layer for now.
All right. Thank you so much, Thibaut, again. Looking a little bit into the cloud and the GPU, the hardware market. So starting with cloud, cloud computing has changed the way companies run their IT systems. It used to be local in the past. Now more and more computation and data storage are now carried out in the cloud. And this comes with many benefits in a way. So for startups, this guarantees improved scalability and flexibility, which the cloud computing provides. So this comes with many, many benefits. And this is not a trend from the past. There are some estimates regarding the increase in the cloud revenues, which basically show that they are about to increase significantly over the coming years. And this comes partly because of the growth of GenAI as well, because GenAI is heavily dependent on cloud services. And here the concern with the cloud market is that basically there's a significant concentration in the hands of the so-called hyperscalers. So here I'm talking about Amazon, Microsoft, and Google. which are basically capturing a growing share of the cloud market. I mean, estimates here again show that in 2017, these three hyperscalers held 50% of the market, and now they control already 2/3 of the market. So this shows really the increase in importance of the hyperscalers. Some competition authorities looked into these markets, and here we have the French competition authority that certainly has something to say about this, but also the Dutch competition authority has looked at these markets. And these market studies, basically, they shed light on the functioning and on the competition dynamics of the sector. And basically, this is a sector that is not basically where you find significant entry and expansion barriers. So I'm talking about the fact that it's capital intensive. You need to basically develop an infrastructure with servers, cooling equipment. You need to invest in R&D. And of course, most of these costs are basically fixed costs, which creates scope for economies of scale as well, which is basically, it's difficult for, let's say, new entrants to actually be able to challenge the hyperscalers. There's also network effects, like the fact that, for instance, there's a large developer community for the hyperscalers, and so a new entrant also has problems with this. And on the demand side, by the way, there's also, let's say, the users of cloud services, they also favor established hyperscalers because of their track record of reliability and security in cloud services, and because they want to get the most innovative cloud solutions. And so in the end, I mean, this is a market that is quite concentrated. There's also some conduct from the hyperscalers that has been somehow targeted, such as, for instance, the limited interoperability, the lock-in strategies, switching costs for users, such as the egress fees. We have now, at least in Europe, the EU Data Act, which should solve some of these problems concerning data portability and interoperability. So let's see what the future will bring in the cloud market. Now, very briefly on the hardware, the chip. So basically here, we are talking about the fact that GenAI systems basically demand specific hardware to effectively process and learn from the massive data sets. And so you need really the so-called AI accelerators, such as GPUs, the graphics processing units, which are the most used hardware because of their ability to accelerate parallel computations effectively. So, and here NVIDIA is really the dominates somehow, or is the leading firm in this AI-focused GPU market. So there's some questions whether this position will remain solid for NVIDIA. The good news here is that there's new players like Intel and AMD, and also large tech firms like Google, Amazon, Meta, and Microsoft. They are producing or planning to produce this sort of AI chips. So this is something to remain vigilant as well, to see how this market will basically evolve. That's it. Basically, just a last words, that competition authorities have also been quite active regarding this GPUs market, this AI accelerator market. So there have been attempts, for instance, from NVIDIA to acquire ARM holdings, and this basically faced a global wave of scrutiny. In the US, it was really a challenge from the FTC regarding, it was challenging this deal, and also the European Commission and the CMA have basically conducted in-depth investigations into this. So this is, again, there's also the market studies from the French authority, apparently, from the Commission regarding this market. So let's see what's going to happen with this market, but it's something to remain watchful. And that's all for now. Thank you.
All right, thank you very much. And we've also heard that OpenAI is seemingly looking for $7 trillion, not billion, trillion, right, for making chips. Now that we moved into some of the challenges in the upstream market, it's a good time to introduce or to reintroduce another of our speakers. And here I have in mind João Vareda from the European Commission. I believe you have a presentation on your plans and activities at the European Commission, and that you are particularly interested in that upstream market. So thank you so much for joining us, and the floor is yours.
Thank you. I'll try to share the screen if you give me a second.
In the meantime, Bo will sing.
Is it working?
Yes, it's working.
Yes.
Too bad.
Okay, perfect. So yes, thank you, Thibaut, and thank you also DCI for the invitation to participate in this webinar. As with my colleagues from the authorities, I'm also here speaking in my personal capacity, and the views expressed don't represent the views of the Commission. Although I'll be talking about the Commission initiatives, but later we'll also probably discuss more about our opinions and our views about this value chain, which will be also very interesting. But just then to introduce, so I think this is, I think, also where Mistral described it, and also the two authorities already described. I think we are now in a market which seems to be very dynamic. There are several players active in this market currently. There are big ones, there are small ones, there are some European ones. Mistral, a very good example of an European company active in this area. However, I don't think we can assume that the fact that there is now competition in the market, which is still nascent, it's a guarantee that there will be competition in the future once the market is consolidated. So I think that's what justifies that we need to be vigilant and see how the market will evolve. And more and more, when companies act on developing their models and start monetizing their AI models, there will be then a probably temptation for some of the companies, the ones that will be dominant companies, to have foreclosure opportunities in order to guarantee this ability to monetize their models. So we need to remain vigilant, and we need to monitor developments in AI to guarantee that that the market can continue being dynamic and can continue to have many companies developing their own models. I don't know, I have here a number of 160 different models that the CMA study reported in their preliminary version. I don't know if now 2 months later there will be more or less, but that's a number that I would like to see in the report, if there is an update of that, to see if the market increased in terms of variety or decreased in the last 2 months. But I think we are still in an increasing wave of variety and models that appear. But regarding now the Commission's initiatives, I think in this context where we see the market is nascent and is competitive, but there are risks, the Commission launched an horizon scanning in this space. And we can say it even started with the AI package when we launched the AI Act. This was not focused so much on competition issues, but also more on the societal issues, more on promoting the innovation in the sector. But this was one of the first big regulatory measures in the AI arena launched by the Commission, and other authorities worldwide are also launching some regulations in this field. Then at the competition space, we launched our call for contributions in January 2024, in 9th of January. This was basically asking all the experts, stakeholders in this market a series of questions. The call was open until the 11th of March for 2 months, and we received around 120 contributions from many stakeholders. So again, from the industry, also from big tech, from the startups, also some observers in the market, some potential applicants, but also some academia, and also law firms and economic consultants that have been looking to the market. And our plan next is to organize a workshop in the second quarter of 2024, where we'll also bring some of the people that submitted their contributions and create a debate around these topics. A second stream of work stream that we launched the same day as the call for contribution was with the Commission sent a request for information to some of the largest big players to ask about their agreements and partnerships with the generative AI developers and providers. So we saw this was a trend. There's more and more of these agreements, and we wanted to see these agreements, to understand what's the motivation for them, and to make sure that they are pro-competitive and they don't contain any anti-competitive clauses. And finally, we are also looking in the Commission to the Microsoft investments in OpenAI from the point of view of mergers, to see if it's something that can be reviewed by our merger control rules or not. This is something that I understand also other authorities worldwide are looking, and this is also part of this exercise. Now, I wanted to go a bit deeper what did GCOM cover with this call for contribution. So here is the list of the 12 questions that we asked. I will not go here reading all of them, but just to say that in what we cover with these 12 questions was we wanted to understand what's the value chain for the foundation models in particular. So we wanted to understand what are the important inputs upstream. So as João already explained, we're looking to data issues, computational power, also talent and capital, and also look to downstream elements of the value chain. So what are the applications where these foundation models will be used, in which devices they will be deployed. So we wanted to understand the full value chain with these questions. We also wanted to understand the business models of companies active in these areas. So how monetization will happen? Will this take place mostly via proprietary models? Will these open source models that we see, how they will be monetized? How they will coexist, these open models versus and the proprietary models? We also wanted to understand what are the main barriers to entry to compete in this area. And not repeating myself, but of course we wanted to understand if this is markets where we will find, like in many digital markets, the scale effects, the network effects, the possibility of switching costs and blocking effects because of people who enter into an ecosystem, then will be difficult to leave that ecosystem. Also, eventually, what's the cost structure, if it's a market with lots of high sunk costs or it's more variable costs, if there are capacity constraints, etc. Another element we wanted to understand is what are the drivers of competition, if this is mostly about price, if this is mostly about performance and quality. So what are the main parameters of competition that will make a difference for the companies to succeed in this market? And then we were also covering in our call for contributions the rationale for the investments of big tech players in some of the smaller startups. And one of the questions that we're also asking to the public was if the current antitrust toolkit is enough to address potential concerns, if there are those. So our Article 101, 102 and merger regulation are enough, or if something else is needed. Now, I will not comment on the results of this call for contributions. We're still analyzing the results. This is something which we'll plan to communicate a bit later, closer to summer, closer around the workshop date, because for now it's still very preliminary and we're still trying to assess and trying to understand some of the contributions that we receive. And finally, I think something that we can already take as a lesson on the base of our experience in the digital markets and the case that we have assessed in the past and how we saw the market evolving. I think important messages already now, it's that it's important to understand the market dynamics. It's important to understand if there are already some potential concerns, if there are already important elements where some intervention may be required. It's important to have this continuous monitoring. We don't want to run the risk of over-enforcing, so we don't want to intervene when there's still no clear risk. I think it's important to understand the market. It's important to identify the problems, but it's also important to have this continuous monitoring to act when the problems are there and not in anticipation of things that it's not clear that they are a problem. Because at the same time, it's important to promote innovation and let and the market work in a way that brings more innovation and diversity. And then so there is also the need to avoid any over-enforcement risks. And I think finally a message, and I'm happy we already have also the presentation of the Portuguese colleague from Yann, from the French Competition Authority. I think many authorities are looking at this, also the Hungarians in Europe, also outside the CMA, US FTC. And I think it's important that we all cooperate in this field to make sure that we come with a common approach, something that can be understood, because many of these market business models are global. And so it's not that we'll find particular business models different in different jurisdictions. I think they are global. And so it's important that we all cooperate and we come with a common approach and we find a way to all together address the potential problems if they are identified. And that's also the way to guarantee that the market it's clear for everyone what are the rules for competition. And I will stop here regarding our initiatives. Thank you.
Yes, thanks a lot. So I think it's very clear from looking at the 12 questions that you submitted to the public and that you just again went through, that the upstream market captures most of your attention. It's not all there is, but And we see that this is where competition agencies may have a role to play right now, because when it comes to the GenAI layer, meaning the applications, it's hard to know which of the players will emerge and will dominate in the future. There is an analogy that I think is pretty accurate here, and that is the one of electricity. Not that GenAI is as important as electricity. Some people may think that, but what is clear from when electricity was invented is that no one at the time could forecast the invention of the electric guitar, and yet one is necessary for the second one, right? And so the same might be true for AI and GenAI, but we are not yet at the level where we know which of the players will dominate that layer. And that brings me actually to you, Thomas. So coming from your practical/academic backgrounds at Clifford, Chance, and the University of Bergen, what do you see as being a potential future in the space? Is there issues that in 2024 we can say are real and should be tackled? Or is the future too futuristic and uncertain for us to really consider that in an academic way?
Yeah, thank you, Thibaut. It's a great pleasure to be here. Yeah, I look at that from the perspective of having been involved rather deeply in most of the major IT-related antitrust cases of recent decades, from IBM to Microsoft to Google, Facebook, Apple. And I think the bottom line answer to your question is no. It's very good that the agencies are undertaking the analysis that they're doing. It's very important to address these issues. And I think they're addressing the right ones. These could grow into issues that deserve to be addressed through cases. But at the moment, as I think you yourself sort of indicated, and other previous speakers have indicated, we're in pretty heavy-duty crystal ball gazing mode. And so my view as a complainants lawyer in most of the big cases over recent decades, it's not ripe for action in any of these areas, cloud, data, or the like. And there, I think one has to keep in mind the tools that one has available. And it's pretty basic, but Article 102, of course, applies only to single dominant players. And for the moment, as I think João indicated, in cloud, for example, there are some big players, but they're competing pretty intensely with one another. So it would seem to me not to be feasible to actually pursue any dominance case in that realm. With respect to data, that seems essentially the same. The only area where conceivably there might be a dominance issue seems to be in chips, where NVIDIA seems to have a unique position in the market, but there's still a big question as to durability of that position. I mean, one can't really pursue a dominance case unless one can build a theory of dominance that it's lasting dominance. And there's a lot of money going into the AI chip-related production, both public money and so how that turns out, I think, remains to be seen. So, bottom line is, I should add though that the DMA is potentially relevant, and there are a number of areas in the DMA that could be conceivably applied over the near term. The App Store issue and ChatGPT's, what is essentially an App Store, could eventually, if the player were designated under the DMA, be subject to essentially the App Store rules, the DMA. So the DMA needs to be considered. I should probably leave it at that. But the bottom line is, right now, I don't think there is any case to be brought. And everything I've heard from everybody else indicates that people are trying to figure out what's going on and being vigilant about monitoring what's going on. I agree that's what needs to be done, but I don't see how there's a basis for any case at the moment. As a complainants lawyer, at least, I don't see anything I'd like to pursue.
All right, so you're not into intense discussions with one or two clients right now as to how to bring a case before the commission. All right. Well, thank you very much. And what you mentioned, the DMA, I mean, obviously, as we know, GenAI is not one of the 10 sectors listed in the DMA. It doesn't mean that the DMA is not relevant, because you may have store, you may have companies with an ecosystem, including GenAI, but also, other core platform services. And
Yeah,
I think
just for example, if I could mention, I mean, some AI functionality might be deemed to fall under the search engine provisions of the DMA, and therefore the self-preferencing rules could be applied and the data sharing rules could be applied. So that's just an example of what you're saying. I think there are a number of such examples.
Exactly. Or I know at some point institutions, maybe represented here in that webinar, considered the personal assistant category. So the DMA will play a role. As I mentioned, the AI Act also play a big role. And the technical development will play at least an as equally important role. And that bring me back to you, Yann. We talk a lot about supercomputers and Google as the TPUs or the big CPUs, and NVIDIA that we've mentioned quite a few times, and other companies. Are there all, I mean, something we like to do in computational law is to look at whether products and services are substitute or complement. Are they all substitutes to one another, or is it, I mean, how easy would it be for a company, let's say a rich company, to compete with NVIDIA tomorrow if the money is there? Or is there something specific in the training of the model that needs to be adapted at the chip level? And for the background, I'm asking you the question because you went to École Polytechnique and you do have an engineering background. So we rely on you to provide us with an answer to that question.
Daunting questions, Thibault. First, I must say that the authority conducted a downgrade in the GPU sector, and that's all I'm allowed to say. So that's one part. It's a subject we're still investigating in our GenAI study. And regarding supercomputer, like you said, you have private supercomputer, but you also have public supercomputer. And for example, in France, we have Jean, which is located at the INRIA, and we have many other supercalculators. And at the European level, there's the Euro HPC, high performance calculation, I think is the acronym. And there's call for project regarding AI. And part of investigation for our cloud sector inquiry, we went to talk with the people in charge of the public supercalculator, and we wanted to assess how a supercalculator could be substitutable to access to GPU. I cannot say more. We're still assessing that, and I hope you will have the answer in our future study. Maybe regarding the GPU, what I can say, and it's public information, is that there's different level regarding GPU. There's the hardware, the technical part, how it's constructed, and there NVIDIA has a small advantages, but not so much. And a lot of people mentioned that AMD or Intel, for example, have a hardware that is almost on the same level as NVIDIA. But the competitive advantage of NVIDIA, it is ecosystem, and mainly it's CUDA software. That's how you can use the chips. And you can see that all the AI community, they use to code on CUDA, for example, and it's very hard for them to change the programming language. And for example, at the French level, we have different supercomputers. Most of them use a GPU from NVIDIA, but there's one that use AMD chips, for example. I think it's located near Sofia Antipolis. And there's very less demand to access these supercomputers rather than the other that use NVIDIA chips, because it's very hard to adapt your code to the other kind of chips. For at the moment, it seems that it's non-substitutable, but you cannot say for the future because there's a lot of money pouring into developing new chips. You have Google with its TPU. And like you mentioned earlier in this webinar, it seems that if you have $7 trillion, you can make new chips that are substitutable to NVIDIA.
Yeah, and that's easy to find, right?
Yes.
So what you described is fascinating, right? The importance of not just looking at it from a purely technical perspective, but also to consider, you know, the habits of the people, the programming language they are used to use. That brings me back to you, João, Vareda. So what I find to be interesting in the European Commission approach, and that will be the last question on the compute, is that on the one hand, you may consider some vertical relationship as being risky, some leveraging power, but the Commission on the other hand is also launching what is as being labeled the AI innovation package to actually support SMEs and provide computing power to those companies. So what do you see the role of the European Commission being in the space when it comes to, you know, this ability to access compute and computing power?
Well, I think, as described, I think the objective here is trying to guarantee that the market is open and more alternatives and competitors, and as I think is described by João, but also by Yann, it's true that NVIDIA has a very strong position in terms of the chips and the cloud. We see maybe, let's say, 3 big players. They are not in Europe, they're all American players. And I think part of the Commission role is also to try to reduce the dependency of some of these platforms that are not located in Europe. So I think there is an incentive, there is an interesting of the Commission to try to have more alternatives in the market, more availability, and part of the projects, not at level DG Comp, is going there. And of course, we at DG Comp, we also have our role to guarantee that this market can effectively work, and there are no lock-in effects, there are no practices by companies that basically try to foreclose potential alternatives. Because I think the worst we can have is that the Commission supporting companies to start producing, and at the same time closing their eyes to potential practices of a dominant company that doesn't allow these companies to develop and to grow, because then it's wasting money because we are putting money in companies where there will be no growth. So I think the tools should be aligned, and we should promote the companies and try to guarantee that the rules of the game are such that they allow everyone to compete fairly.
Yeah, thanks a lot. Actually, Blanche, I promised this would be the last question on compute, but we're so lucky to have you because you yourself and other people working at Mistral are rare to appear in conferences. So, I mean, what's the Mistral strategy here in the space? Where are you training the models? Is that a struggle? Is that something you discuss daily or something you've been accustomed to?
Yeah, thanks for the question. Actually, yeah, I think it's fair to say that it's a struggle. It's a work stream that we have internally to find sources of compute, and there is a sense of scarcity here today. So I don't know whether it will evolve in the right way, but certainly we are making smaller models, and this is a strategy because we think it's smart. It's a smart thing to do, but certainly it's also an adaptation to the market, to the current market. So yeah, and the thing is, it's difficult to have interoperability with compute power because you cannot train a model on several cloud providers at the same time. You need to choose one and train on one. So you can have several sources of compute, but it's a difficult strategy because then you have to optimize your different sources of compute and make sure you use them properly for making models and for inference. And it's not exactly the same infrastructure for training models and for doing inference. So I think, yeah, there is a whole job description here. I think in all the small companies trying to get compute and try to optimize compute and to adapt to the compute available, the strategy of the company.
Yeah, thanks a lot. Actually, now we move on to a second asset that might be central or not in the space. And here I want to talk about skills / talents / hiring people with a great expertise. And I'll go back to you again, Blanche. I think the history of Mistral is fascinating. As far as I remember, the day it was announced that this will be created, because the co-founders lived a big company in the US, this was already in the press, maybe not that day, but in the following days, it was already in the press, and people in France were very excited because, I guess, of their skills. We had a sense that that company could become successful. And yet at the time, it didn't have a team of 50 people. I'm not even sure if the team today is as large. So could you tell us just about, the history and why you think people have been excited about Mistral from day zero, when it was a very small company, not that today it is a big tech company?
Yeah, I think that part of the success is indeed that the three founders were renowned for their great expertise in their domain. So they were certainly great names for founding a company. We also were backed by founding partners that had some influence into having the right partners around the table. So I think that, yeah, from the very beginning, it made some noise with the right people that were ready to invest. And beyond that, I think there was an expectation of the market and of the developers community to have an alternative to the big tech companies, and to have a different tone, a different player, something European, something with a different culture and a different way to express things. So we have a sense that we were welcome by the community, and we are lucky enough to be very welcome every time we launch a new model, and have a success with this part of the community, which is also the open source community and those persons. Yeah. So this, beyond that, it's still difficult to hire people. There is a lot of competition there too. Okay. The packages are huge. I think that Europe is attractive to US talents to some extent, but it's still difficult, even with the efforts that have been made on the European front to have budgets and attraction of talents. We are at the beginning of this story, and hopefully in the next few years, our attractivity will increase. We have a good trademark, but it's better in Europe than in the USA today.
Yeah, this was my following question. So you are struggling to hire, and is there a policy that you should prefer people coming from the EU because you want to have, that as part of the brand, or are you as equally happy if you can hire someone from the MIT or Stanford?
I think we want the best people and the best models, and being a European is not an excuse for being less good. We want to be the best.
Yeah. All right. And of course, you have a lot of talent in Europe hired by US companies, so you can also tap into this big pool. Let me go back to you, João Pereira. So what is your take on scarcity? Do you think this will define dynamics in the space, or that, on the contrary, because you can create a very good company and a good model with just a couple good employees, this is not so relevant?
Yeah, thank you, Thibault, for the question. For a competition authority, and indeed the scarcity of AI experts is really concerning, and this is really a bottleneck, apparently. For a competition authority, the scope for intervention is rather limited, and Thomas already spoke a little bit about the fact when there's no dominant position, then a competition authority cannot really intervene. When we are talking about labor markets, we are basically talking about anti-competitive agreements in labor markets that could actually restrict the mobility of workers. This is normally the line of intervention from a competition authority. You can also have the sort of wage fixing agreements. We have seen, we have seen in the US, for instance, that they have the FTC and the DOJ have sanctioned many standalone no-poach agreements, including in the tech sector. So this is something to actually be aware, in the sense that it's really happening on the marketplace, and this could actually prevent this mobility of workers from one company to another, and prevent, let's say, innovation spillovers and this kind of things. The other concern is, again, the concentration of the AI talent. I mean, there's some studies out there showing that there's a significant concentration of the AI talent in the hands, basically, of the big five, the GAFAM companies. So I've seen studies about this, and this can be a little bit concerning. I mean, there's also the deep pockets can also be a way to attract the AI talent, but it's something that a competition authority could try to see, but it's already moving a little bit outside its comfort zone, is about the contractual, let's say the contractual, when basically there's this, on the work contracts, basically you have these non-compete clauses that prevent a worker from moving to a competing firm. And there, the FTC has also looked into this. I mean, at European level, the competition authorities are not really have the ability to intervene in these kind of things. But I mean, I think this is something for the lawmakers as well to be watchful, because I mean, if there's an extensive use of these contractual non-compete clauses, this can of course be concerning. Just a last word, because here in Portugal we have been so we have the US kind of example, but here in Portugal we have actually been breaking ground regarding the application of competition rules in labor markets. We have also issued published an issues paper back in 2021, and it's called Labor Market Agreements and Competition Policy. It's also available on our website. Yeah. And basically, this was a way to raise awareness among companies about these kind of anti-competitive agreements. And this basically launched a number of complaints. And for instance, even in the tech sector, we have recently intervened to basically tackle a standalone no-poach agreement between two multinationals in the tech consultancy sector that were basically preventing the mobility of IT engineers. So this is something for a competition authority to think about. I mean, there's some advocacy efforts in the form of, for instance, an issues paper or a campaign to raise awareness in the society about these kind of anti-competitive agreements. And that's all. Thank you so much.
Yeah, actually, I wanted to ask you, so because indeed the FTC in a blog post about GenAI said, well, scarcity in talent may be an issue, but we also know there is a political willingness, by the FTC to go for no-poach agreements. They've been talking about it for a long time, and the rules are different. I know that in France, where I was trained as a lawyer, those are very limited. I mean, if it extends 2 years, it's going to be, get considered to be non-applicable. It also has to be limited in terms of scope, geographical scope. Do you know what's the rule in Portugal? I mean, can you go for a no-poach agreement, non-compete clause that would apply for 10 years and apply to the whole country, the whole Europe, or is it also more limited in scope?
Yeah, I mean, for the no-poach agreements, that's very clear that there's a legal framework in terms of an agreement between competitors. So you can apply here in Europe 101, Article 101, because there's an agreement between competitors. When we are talking about this kind of contractual non-compete clauses, unless you have a dominant position, and you could argue to what extent you could actually frame this as an abuse of dominance, then you're a little bit outside somehow let's say you don't have such scope for intervention. One thing that is normally done is when you have a merger control notification, sometimes you have these kind of issues about non-compete clauses, and then you try to limit as much as possible in terms of duration. Yeah. But in terms of labor law, I'm not sure there is really any limit into that.
Yeah, all right, that's very interesting. Let me move on now to you, Yann. So I just gave the answer for France, so I won't grill you about what's the scope of the no-poach agreement in France, but coming back to GenAI, do you see scarcity of talent as an issue? Again, it's very interesting because France is known now, right, for generating a lot of talent and being one of the leading places in Europe. So your perspective has a lot of weight.
Yes, Joe did a very good presentation on all the competitive issue regarding talents and skill, and that's something that we're also looking into in our study. Unfortunately, I cannot say much more about it, but
Just between us, just between us.
yeah, and the wall of YouTube.
Exactly.
But yeah, what I can say is that sometimes we don't realize the scarcity of talents regarding building LLM, for example. And it's one question that my board of the authority asks me, but why is there so few people that can build LLM? Because there's so many open source papers. For example, you have the paper from Meta regarding how they build Llama 2, for example. You have also a very small French LLM that is called Croissant, built by a team from Supelec, and there's also an open paper. So you might wonder, why is there so few people that are that can build this LLM? And one analogy I try, it's like a recipe. You only have the ingredients now, and no one tell you how to cook them, because there's not an article to tell you what's the process once you have your ingredients. And so that's why it's so hard to find people, because the only people that know how to build LLM is people that have been and that have built LLM. So they need to go through Meta, Google, OpenAI, or Mistral now. And so very few people in the world. And so the scarcity will be less important in the future, because more and more people will be trained. But at the moment, the pool of talents is very limited. And that's why also Mistral, I think, was so successful, because they had 3 of these people. And so it's very important.
Yeah, and indeed, and that reinforces the need for looking into no-poach agreements, right? Because as you say, if scarcity is to diminish because you can escape those companies, but the contract is telling you that you cannot, then it may create an issue.
And maybe
yeah,
just if I can add one more thing, maybe in the coming years, we'll finally have, this big article that tell you the exact process on how to build a LLM. Maybe.
So what about a competition agency publishing that paper in a way to stimulate competition?
Yeah, if you can convince the French government to give us 50 people, sure.
Okay, I'll take care of it. You mentioned Croissant. It's a very good example. Living in the Netherlands, I can tell you that sometimes they do have the ingredients. It doesn't mean that the result is as good as you may expect. And Christophe in the chat is saying that there is another foundation model put out by Facebook, called Camembert or Camembert. So, and the same may apply, right? It's not because you have, I don't know how you make Camembert actually, which makes the point. In any case, let me move back to you, João, Vareda. So is the Commission looking at that as well as being one of the key variables defining competitive dynamics in the space? After all, it's a DCI event, so we have to talk about dynamics.
No, yeah. So as I said in the beginning, I think when in our contributions, we're asking about inputs that are important, and we understand talent to be, in this sense, I think in particular for AI, clearly one of the important inputs. Also in the questions that we sent regarding the contracts between the companies, of course, that was also when we get this contract is also something we are looking to see if there are eventually non-clauses included in those contracts. So it's something that clearly is not that, again, I cannot talk about the results of our contract because we don't have the final results, but it's something that at least on the basis of the public studies and then that we see in the press, I think everyone is speaking about talent being scarce. And if that's the case, these type of clauses can have a serious impact in terms of the development of alternatives. And so it's something that we will need to look. And it's true that we have not done any no-poach agreement assessment in the European Commission. The Portuguese is one of the exceptions in Europe that have done so. But that doesn't mean that in the Commission we are not open to do such a things. We recognize it's a possibility for a 101 case, an Article 101 application, although for now we have not found the case to run it. But maybe related with this, which is a bit what we are now recently, last 1-2 weeks ago, we saw it a bit the opposite, which now people come also to the the public, referring to some concerns, which is basically when a big tech company, in this case was Microsoft, just basically hired a big group of engineers from a given company, and so that's something that now people are also concerned, and even our commissioner Vestager, she mentioned about it because she was asked, and then she basically, it's true that it's something that it's not it's not like buying an asset, which is what we look many times in mergers. It's basically hiring the employees of a given company. So it's not that we can look at it from the merger point of view, at least not with the typical way as we look to mergers, but it's something that we need to also pay attention, because there's also the risk that, as we refer, the big techs have big pockets, they can pay a lot of high salaries, and there's also the risk that the big techs will end up hiring all the big engineers from small startups that are appearing, and somehow this can even result of basically one company disappearing because all the amazing engineers went to somewhere else, and because of scarcity, it's very difficult to substitute them by some other engineers. So it's also very difficult. It's not obvious what's the legal tool that we have to prevent this from a competition point of view, but it's something that we probably should also pay attention and see how the trade evolves.
Yeah, and again, the scarcity or non-scarcity, I think, may play a central role in the analysis, in that merger control analysis. If I go back to the EU merger control guidelines, you see that a merger has to be notified, of course, if it's above the threshold, when there is a change in control. And here I quote, where control shall be constituted by right, contract, none of that, or any other means, which could be acquiring the employees, but you will have to prove your employees are irreplaceable, because if they are not, then you can just, as a company, hire some more employees and then run the same companies. So scarcity or non-scarcity may have a big impact in the analysis. Now, let's move on to the third asset or variable that may define competitive dynamics in the upstream market. We covered compute, we covered skills or talents, and the third here is data. Now, I'm pleased that we didn't talk about data first, because this is usually where we start, but we do have to talk about it. So I'll go back to you, João, Vareda. Which data are we talking about? Are we concerned about big data? Or are we concerned about single data, unique data, data that is in the hands of just a couple companies? I mean, what's the scope of the analysis here?
Again, I think we're learning a bit about it. I think what is obvious for now is that these models require vast quantities of data, not only for the pre-training phase, but then later for the fine-tuning phase. And so ready access to data is an important factor in terms of the market dynamics of developing generative AI models. And I think something that is important when we talk about vast quantities of data is that there is a limited amount of free available data out there. So I think for now, many companies maybe are still developing their models on the basis of this freely available data that they can scrap the web. But there is a risk that at some point these models will require a level of data that is cannot anymore be covered by what is freely available. And there it's where it starts to become more relevant, the property data that can be purchased and then basically purchased by from publishers, from image repositories. So it's important to start looking to some licensing agreements to have access to this type of data. But it's also important to take into account that many of the big tech players, they own user-facing services like search engines, like social networks, like marketplaces, which generate a lot of data, and which data that they have a privileged access to it, because it's their data that from their own services. Yeah. So in that sense, it's important for us to see if there is a risk that when more data may be needed and used, the big tech players will not emerge as the only survivors, because all the small ones will not have the data on their own services, or will have to pay a very high price to third parties to have access to it. So yeah, these are important questions that we are trying to assess currently, and now where the market may evolve. And this basically implies, to answer the question, is the proprietary privileged data an important input? Is the freely available data still enough or not? And where is the market going? I think another element that is referred, that we also don't know still much about it, is the possibility of using synthetic data, which is basically data that is artificial generated by foundation models, rather than data that is collected from real world events. And here there's also many public studies and researchers that say this may be a viable alternative to drive future improvements, given that it gives a way to have access to cheaper data. But there are other views of people that say that there may be a risk of using this synthetic data because they may be generated, if they are generated by foundation models, they may already incur some level of degradation, and this level of degradation then is propagated in the future models the more we use it, data from the old model. So there is also this question: is synthetic data a good substitute or not, a good alternative, a good cheaper alternative to the current available data? If we get to the point where the free available data is not anymore enough, and we have to have access to big data that is only in the hands of fewer companies.
Yeah, let me just quickly comment on that. So you say it may be viable or not to use synthetic data. Now, if you consider the question, you will not now need to add GDPR to our discussion, right? Because the use of personal data or the use of personal data for the purpose of training synthetic data may be an issue you may be encountering. And of course, coming back to the AI Act, we know now that foundation model must be sufficiently free of errors and representative. So it may be that it's not only viable for you to use synthetic data, but that in fact you have to, in order for your data set to be representative. Let's say you want to do face scanning, and if you don't have all the population being represented, synthetic data may be the only way for you to comply with the AI Act. So very interesting regulatory dynamics here in the space. Now, something key that you also mentioned is buying data. And here, there are two kinds of data that you may want to buy. The first is data that you don't have access to as a company. Let's say private data regarding, the way a company functions. This is not yet public, so you may want to buy this, or you may want to buy access to data that you have access to, or that at least you can see. And a good example of that would be YouTube, I guess, right? We can all watch the video. We can all have access to the transcript of the video, access to the comments. But if Google decides not to allow you to train your foundation model with that data, then that's it. You can't do it because copyright is telling you that, well, that will be an infringement, although it may be central as a way to understand trends in society, what young people want to do, don't want to do, and so on and so forth. That brings me to copyright. And here, Blanche, I have to go back to you. You are specialized in, amongst all the things, in competition issues, but you also have to, as in your role as general director, to take into consideration the dynamics between competition and copyright and privacy. And I know that Mistral is considering the impact of copyright law on its training models and outputs very seriously. So what's your take, and how big of a deal copyright is for you as a company?
I think you said a lot, and it's a very interesting vision of it, João and Thibaut. What I can say is that our perception is that the law is not clear in the US and in Europe, or maybe not clear enough and not yet stabilized. Probably there are reasons to think that case law may evolve or not. We don't know yet in the US. That maybe the 2019 directive is going to be rediscussed, and there is also some additional layer with the AI Act, where there is kind of an additional disclosures that kind of relates to the 2019 directive. So it creates a dynamic that is difficult to analyze today and to anticipate. What is for sure is that small companies will not have the same easiness as big companies to get a network of contracts. And the prices that we see for those data sets, whatever the reason, you said it perfectly well, Thibaut, one of the reasons could be that it's not available. Another reason could be a different analysis of what copyright allows or doesn't allow, copyright law allows or doesn't allow. But the result is what we see is prices that are kind of disconnected from the reality of what training a model is, because you need trillions of tokens. So in the end, there will need to be a fair discussion and a fair conclusion on this on every side of the Atlantic. And with in mind that reopening those rules could create some distortion of competition when small companies cannot afford the same means as big companies in this respect.
Yeah, that's the main challenge. Now we also see competition not only between companies, but countries. Japan famously now is allowing the training of foundation models on every available data on the internet. So this may create, kind of a loophole in a way to attract companies on the Japanese soil. But if I may ask a following question, what is your take on certain companies? And I'm not sure, to be frank, if Mistral is offering that to its users, saying that if you generate text or a picture and encounter some copyright issues down the line, then that they will cover the cost of litigation for you, right? As a way to attract users. Are you offering that? And what's your take on the practice?
Yeah, I think there is a huge expectation of the customers to get that guarantee. And in a sense, it seems fair that the risk is balanced this way. I would say that you've got to be cautious on the usage that customers do as well, because there are certain usages of AI where it's questionable who is doing the infringements, I'd say. And I think it's quite interesting to look closely at the terms of those guarantees in the contracts, because they have those kind of considerations in mind, which I think is fair.
Yeah. But to some degree, you've mentioned big and small companies. If only the big companies can afford that, this may also create, some sort of reduce the attractiveness of the companies that cannot suggest or offer that to their users. Yeah, if you want to say anything.
Yeah, I agree. I mean, it's a very difficult question, and all the more difficult that, again, the legal and regulatory environment is not clear. Yeah. So when you're offering that warranty, you don't know exactly what you're offering.
Yeah, my job is kind of to answer difficult questions, but the role as a moderator is so pleasant in a way, because I get to ask the difficult questions. João, Pereira, coming back to you. So we've talked a lot about the importance of data, but I guess there is one distinction that has to be made between the pre-training of the model and the fine-tuning of the model. So could you, in just a couple words, explain what the difference is between those two stages, and what role data is playing in either way?
Yes, I mean, Thibault, I think it's an interesting question. And picking up also on the GDPR issue that you raised before, I mean, when we're talking about the input data that users put on a chatbot, I mean, to what extent should this data be used just to adapt to the specific preferences of the user? Or to what extent can it be used to train the model? So, and there you have the question, is it for fine tuning or to train the model? And I mean, if it's to train the model, there maybe you have some privacy concerns, because then you have the risk of disclosing sensitive private data to the wider public. Yeah. And we all know that now, especially following the court of, at least here in Europe, following the Court of Justice ruling on the Meta case, there is some scope for intervention for a competition authority. There's a very interesting intersection between, let's say, data protection and competition law, which gives some scope for intervention for a competition authority. So this is also something that competition authorities should be watchful about. And then just picking up also on one of your points on the AI Act, where you basically say that basically these chatbots need to be free of errors. So they need to remove these kind of hallucinations that we are seeing. Again, here, I mean, you can see there's a race between the big tech firms to actually have the cutting edge chatbots and ultimately maybe even reach the AGI, the artificial general intelligence. But I wonder to what extent can a smaller GenAI model be able to actually compete effectively? Because there's a number of things here that and there's some uncertainty still at this stage, because there's, for instance, a trade-off in the sense that more data requires more computing power. So there's additional costs if you want to use more data. And we have seen that more data does not really mean that the hallucinations are removed. So you see in the big players also the same kind of let's say biases and the false outputs that do not comply really with the AI Act. And then there's also the issue. So can a smaller firm, a smaller operator rely on, let's say, a smaller but a high quality data set that compensates for this lack of quantity? And this would actually come with the benefit of lower training costs. So this is something that it remains to be seen how a smaller operator can actually have a chance to succeed in this market. But we are seeing also advances in computer science, in analytics, and which are making the amount of data maybe less relevant. So this is something to bear in mind and to stay tuned.
Yes, indeed. To be fair to the final version of the AI Act, it has to be sufficiently free of errors, which is something that appeared in one of the recitals of the European Commission, but not in the article, and was eventually reintroduced in the actual article, which will be ground for litigation to be sure. But something you've mentioned indeed is whether or not what I would like to call good enough foundation models could compete. I mean, to some degree, you know, if it's invisible to 99.9% of the users that the prompts or the results are as good, well, it may be a good, efficient way to compete, which is a lot of what Blanche actually explained when it comes to Mistral strategy. Yann, I believe that you have a few thoughts on the subject. Again, coming at the distinction between the training, the fine-tuning, and perhaps introducing here the grounding.
Yeah,
The model.
the third use of data, the grounding, is when you use a query to optimize a prompt by a LLM model. For example, if you ask a question about recent events, usually the information will not be in the training set, because at one time when you train a model, you need to stop the database to fix it. And so, for example, in Gemini, but also in Bing, the way that the LLM answer is that it does a query taking part of your prompt to have the information regarding recent events, and after that, it goes through the LLM and you have your answer. And that's what we call grounding. And it's not the same dynamics, you know, regarding the data that you need for training, because there you need a lot of data. Whereas for grounding, for example, you need data that is relevant to a specific query, and usually is something that are related to news, for example. And what I wanted to mention is that regarding that, the authority just fined last month Google, another time in the related rights saga, a fine of 250 million to non-respect of the commitments. And among the developments, the investigation team found that content for press publishers was used by Google in the training phase and in the grounding phase of BARD at the time, it was called, without the information of the press publishers.
Yeah.
So what I wanted to conclude is that I think the questions of remuneration for the data is very different, whether it's for training as to whether it's for grounding, that is more akin to related rights, for example.
Yeah, and it's precisely why in the database that I've constructed with all investigations that are relevant to GenAI, I did include that decision of the French Competition Agency, because it's not as if you could only look at what is specifically tailored towards GenAI and understand the dynamics in the space. So thanks a lot for that. Thomas, maybe if I may ask you a question, as you said, you've been on the side of complainants companies in a lot of big tech cases. Now, data plays a central role in not all of those cases, although all of the big tech companies are data intensive. But in some cases, we saw that big data and the ability to acquire a data set was problematic. And have in mind Google Fitbit and Microsoft LinkedIn and other related cases. So if you look at GenAI, do you forecast data as being a central part of the analysis? And what is your expertise dealing with the European Commission and other competition agencies? Do they take data as seriously as you would like them to take? Or do you think that they have room for improvement?
Well, let me start with your last question. At least with respect to the European Commission, I think the Commission takes data issues very seriously. I might on occasion have wished that they took some of them more seriously, but in general, I'd have to say they're very much on top of the data issues. Yeah. In terms of how I see data issues playing out in the AI sphere, I'd have to say that it's, at least now, very different from cases I have addressed in the past, such as Google shopping, Google search related cases, where Google clearly has a significant advantage in search query data, in particular long tail query data. And that in very large measure is the source of its dominance in search, because it frankly does give them advantage in search quality and very much drives their dominance. I don't see anything like that. That's an uncommon thing. And I don't believe that the search market necessarily is a winner-take-all market. I don't think it had to end up that way, and I don't think it necessarily has to remain that way. But I don't see anything like the situation with Google in search existing or even arising, although my crystal ball is very limited, in the AI space. But I do think that it's important to start, and I think the authorities in analyzing the AI space are doing this, to start with nuts and bolts. I mean, if we're talking about potentially pursuing cases related to AI, first one could consider Article 101 cases. Frankly, I'm not sure what they might be, but they might exist. But I think we would be mainly in Article 102 territory. And then obviously we have to start with the nut and the bolt of market definition. And is there one market for data for AI or training models or even more specific areas? I tend to doubt that there's one big market for data. I would think that there are markets for specific types of data for specific purposes with respect to AI development in particular. And I'm not prepared to identify what those markets might be as I sit here right now, but I think it's a key thing to do. And then once one has identified what those markets would be, then one, of course, needs to turn to the question of dominance. And then one needs to address issues like previous speakers have addressed, João, from Portugal, for example, from the Portuguese authority, I should perhaps say, is to what extent is that data that falls in that or those markets available elsewhere? Is it available for purchase from others in sufficient sources? Is it such that any company within that defined market actually has sufficient control over the relevant data to be deemed dominant? And then I think one has to address the theory. I'm looking at this obviously from a complainant's perspective, trying to build a case without having one in front of me. But what is the theory here? Is it a refusal to supply theory? That one company would be dominant in some market for data, and it's not supplying it appropriately. As we know, those are very difficult cases to pursue. I've been through Microsoft interoperability and other cases, so I wouldn't shy away from it necessarily, but that's not an easy territory to attack.
Yeah, thanks a lot.
Hope that answers your question.
Yes, it does, of course. And I mean, indeed, defining the market for data, especially when the European Commission is creating now data spaces, so you see that it's all connected, but will be a central challenge. Maybe one last question on the upstream markets to you, João, Vareda, from the European Commission. I believe something we did not mention is capital, access to capital, right? And this might be one of the biggest difference between the US and Europe. Blanche mentioned that in passing already. Is that something that concerns the European Commission? And again, I will come back to, kind of the same spirit of a question. How are you using stick and carrots here in the space to try to make competition dynamics?
Yeah, regarding access to capital, it's also a bit also different. It's not the typical input that we look, or who is the dominant company for supplying capital. There is no such a thing. It's like data. But I think what we see related with capital is these minority shareholdings, these agreements where some companies are basically investing big amounts in smaller startups, and because the small startups, I think they need money. I understand, and sometimes in some of these inputs may be quite expensive. And there's a requirement for having capital, and we see these relationships that can be motivated by that need to have access to capital. And so there may be some pro-competitive elements associated to those contracts, those agreements, because if you need capital, then that's probably one of the few sources of capital that you can use. I think what we as competition authorities need to pay attention is, and be vigilant, is that if, as a counterparty to this capital that is being injected in some of the startups, there are no conditions that will then limit the growth of these companies, and then there will be including non-compete clauses or exclusives, their relationships. So I think that's the counterparty for us in terms of the factor capital. It's okay, it's maybe pro-competitive with what conditions are associated to the access to that capital, and that's something that we want to understand, and that may have a decisive element of how these smaller companies can evolve in the future and can compete freely in the future.
Thibaut, you're muted.
What about now? Okay, no battery on the microphone anymore. All right, as I was saying, it's good that I managed to change microphone. Otherwise, my reputation as a moderator of GenAI is ruined. As I was saying, we do have a question so I was saying, first of all, yes, it's very important indeed that the Commission looks at that. So thank you for doing the work. And one question we have in the chat before we move on to part 3 of our conversation relates, and I will kind of reformulate the question to what may be the tragedy of the commons now. Of course, we have the work of Ilona Ostrom showing that there is no such a thing, or that it's not inevitable. But I guess the question would be, if we do give the right to, let's say, small companies to train their AI models based on fair use, as opposed to saying they have to acquire licenses all the time, isn't there a risk that some data providers, let's say newspaper, will then shift in business model and say, well, you know what, you can't access data anymore. It's behind a paywall, because that way I know for a fact you won't be able to use the data. Who wants to answer this one? I mean, of course, I'm asking you to look at the crystal ball a little bit and forecast the future. I would take that as a yes. That's a big risk, and we should consider that risk. All right, but it shows once again that we have to. Yeah, you want to say something?
Maybe, but it's not my own thought. It's an article I read from, let me just say the name, Bertin Martens, regarding economic arguments in favor of reducing copyright protection for generative AI inputs and outputs. So that's my source. And he said that in France, SACEM, with the holders of musical rights, did in fact opt out from, it's behind a kind of, not a paywall, but don't want to be scraped for training. And the question is very complicated because in the EU copyright law, you have an exception for TDM, text and data mining. But when it was put into the law in 2019, no one thought about GenAI, and GenAI poses a new problem in terms of scale. And so it's very hard to answer the question because there's also a problem of remuneration for the press. For example, they saw their revenue from apps drop dramatically due to the competition of the ad tech sector, for example. And so they're trying to find new sources of revenue. But I think Blanche mentioned it before, the marginal value of the data is very small for training because it's just a drop of water in the ocean of data training. And so I'm not sure it's where the value is located for press content. It's more related to the news, to the fact that you have valuable, precise, verified information, and not much more for training. For example, you can compete, I think, with Wikipedia in terms of training data.
Yeah,
but
and we
that's
have
my
previous studies.
personal opinion.
Yeah, of course, showing that Wikipedia is more accurate than some encyclopedias. But one outcome, I mean, some people have said at least that one outcome of the OpenAI versus New York Times lawsuit might be that if the Times is successful in negotiating what they will want, you could end up with a version of ChatGPT that tells you that the source is actually provided by the New York Times as a way to increase trust, right? And not having the possibility to do that would decrease trust if that becomes common practice, but obviously this is hard to forecast. That brings me to chapter 3 of our discussion. Not that it is not important, but again, it's more of a crystal ball exercise, so we've decided to devote less time to it. Here, talking about the downstream markets. We'll start with the issues because, again, as lawyers, this is what we like to discuss usually. And I'll go to you, João Pereira. So here, looking at how GenAI might be used for bad reasons, and one of those might be algorithmic collusion. Now, a paper was just published that week showing that in a lab, it is indeed possible that GenAI will decide by themselves, quote unquote, to collude. So what's your take on it and how big of a risk you think it is?
Yeah, thank you, Thibault. I mean, this is also a fascinating topic that we could spend the whole afternoon speaking about algorithmic collusion. I mean, there has been many discussions about this over the past decade. I mean, the issue here is to what extent, I mean, we had advancements in machine learning, in deep learning, and now in generative AI. To what extent now generative AI actually offers, let's say, can become a powerful assistant that basically supports firms in their marketing decisions, including on the definition of prices, and to what extent it can facilitate some sort of algorithmic collusion. And there's a big debate, as you certainly know, on whether competition law can actually intervene in some types of algorithmic tacit collusion, let's call it this way, when basically the collusion arises autonomously where the algorithms interact with each other without any intentional conduct, without awareness or without communication between humans. So there's this very fascinating legal debate on this. Just a few words, because back in 2019, the Portuguese authority has also published a market study. It's called Digital Ecosystems, Big Data and Algorithms. And we already anticipated these risks for algorithmic collusion. And we even voiced concerns about the use of these third-party algorithm, price algorithm providers. So this could be, let's say, a way to have a sort of hub and spoke collusion. And this is something that we have been monitoring since then. I mean, I could explain the literature. I mean, there's many literatures, theoretical. Calvano, for instance, shows that self-learning algorithms can actually reach tacit collusion. There's more recent attempts on more empirical research. There's an interesting paper from Assad focusing on the German gasoline market that shows basically that the use of algorithms in this market basically led to increases in profit margins. But all in all, I think what comes as a surprising fact is that there has been many papers, many discussions, but we don't see that many cases, competition enforcement actions tackling this type of algorithmic collusion. So here it's really the crystal ball, like you were saying, and here we are basically just considering that this time it might be different because GenAI might bring this to a whole new level because of its additional capabilities in terms of mimicking human intelligence and understanding data at a deeper level. But all in all, I mean, this is really the impact of GenAI on algorithmic collusion is really something that remains as a topic for ongoing research. And I take the point that there's now already some papers out there that are starting to be published on this matter. Thank you.
Yeah, thanks a lot. So, so now moving on to what might be a challenge, but also opportunity, I want to talk about business models. So one could argue that the kind of a 10 blue links business model, which has been the one of Google, is on the edge of becoming obsolete, right? If you can instead prompt a foundation model or GenAI app to give you the answer you were looking for, this could actually put some pressure on Google to cannibalize its own business model. And in fact, when Google announced that they were moving towards GenAI, I forgot the exact number, but that day when they did a call for investor, the market cap of the company decreased by a lot because they showed willingness to cannibalize a business model that is working, but it might be the only solution. Okay, that's the great story. Now, the danger is, or at least some may see it that way, that some of those players may invest in mergers or acquisitions as a way to prevent disruption, right? And that leads me to you, Thomas. What's your take on it? Do you see merger control as being the top priority for practitioners such as yourself and also competition agencies? And should we be concerned right now, or is that okay if we take a nap and wait a couple of years?
I wouldn't see merger control as the main tool to use in this area. I think that if, for example, Google were to undertake a killer acquisition, as they're called, to prevent an AI-based competitor from arising that outside of Google would cannibalize its business, then that seems to be something that would be rather urgent to address. And I would think there would be a pretty strong basis for competition authorities to address that sort of thing. More broadly in the AI area, clearly competition authorities are looking at merger control as a potentially important tool. I can't say that I have seen any transactions so far or on the horizon that would be particularly important in addressing competition issues, though, in the AI space. But clearly, it's a tool that competition authorities are going to be considering using, and they should.
Yeah, along with the DMA, as you mentioned.
Of course, the DMA, yeah. Of course. The Data Act is also potentially relevant with respect to helping to facilitate switching in the cloud context and the like. So it's one other of this great, great variety of new regulations.
I didn't want to mention that. Yeah, because we are making people nervous now because tonight will read about the AI Act and consider copyright and GDPR and privacy and now the Data Act. But indeed, I mean, it seems that we have no choice but to consider the dynamics those acts are imposing on the market.
And how they interact. I'm not sure how they do interact, but that's a big question.
Yeah, the trade-offs, and I think it will put companies to some degree in a difficult position sometimes as to which one they should comply with in priority, especially when they conflict, but subject for another day. Something which is another strategy maybe that some companies may have might be not to invest in mergers, but to make their model interoperable, or at least to try to acquire access to another model provided by another company. And that brings me back to you, Blanche. What's your take on it? How is interoperability shaping the dynamics on the market? Is it something that you are considering at Mistral? You've mentioned open source already. So how do you see that evolving?
Yeah, what we're seeing at Mistral is part of a strategy is to, we think customers want to have access to any model the way they want anywhere. So I think that the achievement would be that cloud providers give access to a lot of models on their different platforms, and customers are free to move from one cloud to another, from one model to another, super easily. So that would probably be a target, a very good target for the markets. And this also extends to the capacity of the customer to do on-premise, for instance. And I think here it gets back to a bottleneck that we identified earlier, but today it's not certain that customers can easily do on-premise because they may not have an easy access to the compute power or to the talents that make it possible. So that would be also, I think, something customer wants, having this possibility, this real possibility. And the last step, I think, the extra one that would make this very interoperable would be that those hyperscalers, those cloud providers who are also providing services in which they put AI, they give a choice to customers into what AI there is into those products, into those services. So that's, I think, the ideal picture of what would make the market really open from end to end.
Yeah, quick follow-up question. Do you see open source, which tells a lot that I called OpenAI open source? Okay. Do you see open source at Mistral? I mean, again, you're not talking, representing the entire company, but is it something that you are doing for almost like a moral stance because you think it is necessary because we need diversity, variety on the market, or because it is a good business strategy?
Yeah, I'd say both. We have a real commitment to open source because we want customers to be able to touch the models, to see what this is, to use them, to really adapt the change, and we think it's super important for the whole market adoption that everyone understands what AI really does. And it also addresses some of the concerns of the AI Act, which is once the customer gets educated and appropriates the new technologies, the change, then you've eradicated a lot of fears and issues that this market could bring. So I think this is a commitment on the long term, and it also can serve some certain type of customers, like doing research or things like this, where it makes sense that we give back to the community.
Yeah. All right. Thank you. So that's what a company can do now. Final question, and then I would be disappointing Bo if I didn't have a bonus question for all of you. But final serious question will be for you, Yann. What can a competition agency do in the space? So what is the role? We know to enforce competition law, but how can you go beyond that and have an active, positive role in the conversation?
I think it's our duty as a competition authority to put awareness of competition problem to the whole world, because when I followed the debate around the AI Act, for example, competition wasn't on the radar. It was only risk regarding sometimes science fiction risk, but risk to consumer, but no way risk to competition were envisioned. And I think we have a role to play to put competition on the table. And that way, the legislator, can have all the different variables to, after that, make a choice in a good knowledge. But I think it's part of our role, a modest one.
And I shall say that the French competition agency is doing that when it comes to the general public, going in the media a lot, but also when it comes to more of the tech/dev developers community, you have a GitHub, which is not common for a competition agency. So this is also you giving back to the ecosystem.
Yes, we have a GitHub. We're present on the datagouv.fr, where our databases of publication are freely available. And for example, I participated in the French AI Day last week, organized by France Digital. So we try to go to meet the businessmen to do.
And you're here on this panel today. Okay, so I have two bonus questions. The first, maybe it's good that I see all of you. Who, and please raise your hands, use generative AI today? Okay, most of you. Final question to each of you. What is the most common use you make of GenAI? Is it work-related? Is it to create poems? Maybe Bo is doing that a lot. Okay, I'll start with you, Yann.
Two answers to your question. At the authority, we're currently fine-tuning LLM. So that's one use of GenAI. And on a personal use, I use ChatGPT a lot for writing materials.
Okay, good to know.
Very good. You feed ChatGPT just bullet points. After that, it writes you 2 pages AC, and you just have to adjust some formulations.
Yeah, all right.
Saves a lot of time.
Don't tell that to my students, please. All right. João, I will start with you, Vareda. What is the most common use you make of GenAI?
Well, private use, I think that there's something similar to ChatGPT. I think now in the commission, we also have now planned to introduce more AI systems in our daily work. So the recent one, it's like AI for briefings, where basically we can collect all the briefings that were wrote for a given meeting, and then basically just extract that and create their own briefing, because it's something probably that we do so repetitive that an AI can do it already at a very high quality.
Yeah, poor Blue Book trainees whose job is going to disappear. All right. Although I doubt you will find a name that is as good as Le Chat, which is the one of Mistral. So I will go back to you now. Blanche, what is your most preferred use of GenAI?
Before I disappear on the screen.
Yes, we know now that you are, we know that we live in a computer simulation thanks to you, and that you are
exactly. So yeah, I use it a lot for drafting, which will not be a surprise to you. So I draft a lot of contracts and a lot of arguments and speeches and ideas with Le Chat, and it's never disappointing. And I also do some translation, which works super well.
Yeah, all right. I like also how you pronounce it in a French way, which is what we do. Thomas.
Well, I took your question as to whether I'd used GenAI today, this very day, but now
of course. Yeah, today as well.
Okay, I haven't used it today. And frankly, for the things I write, I haven't found it to work terribly well, to be very blunt. Yeah. But maybe that's because I don't use it properly. But I have a question. May I ask a question of the authorities quickly? Have any of you contemplated or actually used AI to detect or to seek to detect algorithmic collusion? Because I've heard and read that is a possibility. Maybe.
I'll ask you for a yes or no answer.
Yeah.
Time. I will take that as a no. Okay. All right.
Actually, in
Portugal, go ahead.
We have a web scraping tool. It's not really GenAI, but we might get there at some point.
We have
a web scraping tool to actually try to uncover, let's say, patterns of parallelism of prices, for instance, or conduct. And so we have this tool that we use for the detection of anti-competitive practices.
All right, I'll be failing my role if we finish in more than 1 minute from now. So João, Pereira, please, what is your most common use of GenAI?
Well, I use it to get the inspiration, to basically collect information on a specific topic, also for drafting sometimes, and to summarize documents. That's mostly what I use for.
All right, good. I'll ask you the question and then give you back the floor in any case.
Sure. So I think I like it it is very good at language, obviously. So it's poetic as I think that I am. I like to run things through and see what it comes up with. And not everything's great, but some things are great. I think it's good as a sparring partner. It comes up with the hallucination is a feature for me. I like that it hallucinates a little bit.
Makes life interesting.
I think what could be good for a panel like this is you could write in, what is Thibault Chappelle likely to ask me as the bonus question? It might now have enough training data to help you out with that beforehand.
Yeah.
But so I can finish up from there. I would like to thank all the speakers for your insights in this important and, of course, dynamic topic. This is, what do we say? It's not dog years. It's, maybe mice years. It's going quickly, right? And we want to stay on top of this. This is one of our key focus areas at DCI, and we'll be addressing this through our Dynamic Competition Policy Lab, as well as at our annual conference coming up in October, and through our research and our requests for comments to policymakers. I commented, Thibault, that I didn't use ChatGPT for the request for comments on GenAI because that would be a conflict of interest. So, but sometime in the future, I suppose, policies will be put out by maybe the AI Act. The next version will be put out by AI. We'll see. But things are switching very quickly, and it's been great to listen to all your talks. I know I learned a lot, and we're going to input a lot of this knowledge into what we're doing at DCI. And of course, a special thanks for you, Thibault, for great moderation. You're still the GOAT of moderation. That's not an animal.
Well, I made someone
acronym.
disappear. I made someone disappear
That's
today.
right.
First
That's
time
it.
ever.
Blanche is disappearing into the ether.
That's amazing. You did it so well.
It's just a smile left. It's like what is it? Alice in
It's
Wonderland.
just cat smile, yeah.
That's
it.
All right. So take care, everyone, and we hope to see you again